Hi Jonathan, we'll be doing the case of Annetts versus Australian Stations. In our case, we will be representing the plaintiff. My name's Nikki and I'll be doing the case summary.
My name is Xiaoyu. I will be discussing the legal issues arising from Annetts.
My name is Cynthia. I'll be doing the plaintiff arguments.
My name is Mike. I'm doing the conclusion.
So I'll be doing the case summary. In August 1986, James Annetts, a 16-year-old, left home to work for the respondent as a jackaroo at Flora Valley Station in Western Australia. In October 1986, he was sent by the respondent to work at Nicholson Station, a very isolated location. James was left there unsupervised and alone with only radio communication to other properties of the respondent. James decided to run away from Nicholson Station, but the car became bogged and he died in the Gibson Desert on about 4th of December 1986. The applicants are the parents of James Annetts. On the 6th of December, the police made a telephone call to Mr. Annetts and informed him that James was missing and it was believed that he had run away. Mr. Annetts collapsed when he was given this news. In January 1987, both parents went to the Halls Creek police station where they were shown some of James's belongings, including a hat covered in blood. It was only on the 26th of April 1987 that the car was found, and later that day, James' remains were also found. Mr. Annetts returned to Hall Creek and was able to identify James from the photographs of his remains. The applicant sued the respondent for damages on the basis that the respondent's negligence caused the death of James and that same negligence caused each of them to suffer psychiatric injury. On the application of the respondent, the Supreme Court of Western Australia ordered that a preliminary question be decided. That question was, on the basis of the assumption of the truth alleged in the pleadings, did the respondent owe Mr. and Mrs. Annetts a duty of care? The preliminary question was heard and decided adversely to the applicants. The full court dismissed the appeal. The court found that it was not reasonably foreseeable that the applicants might suffer a sudden sensory perception of a phenomenon so distressing that a recognizable psychiatric illness would be caused. The court also found that in order to establish the necessary degree of proximity to recover damages, the person who has suffered psychiatric injury must directly perceive the distressing phenomenon or its aftermath, and on this basis, the applicants failed to establish the necessary degree of proximity. The application has been referred to a full court to be argued as if on appeal. The question of law said to justify a grant of special leave to appeal is whether the common law of Australia governing the recovery of damages for the negligent infliction of injury should continue to require different rules to apply, depending on whether the injury is characterised as physical injury or psychiatric injury. In 2002, the High Court unanimously upheld the Annetts claim, the majority finding that their psychiatric injury was a reasonably foreseeable consequence of the negligence of Australian stations, and they were therefore entitled to compensation.
I'm going to discuss legal issues arising from Annetts. At trial and on appeal, the law removed the suffering of Mr. and Mrs. Annetts from the tragedy of their son's disappearance by virtue of the geographical distance between them and their son at the time. When the Annetts sought damages for psychiatric illness resulting from the defendant cattle station management's negligent treatment of their son while he was in their employer, they confronted the shock or sudden sensory perception obstacle of the relevant legal doctrine, as it was the way in which they came to know about the disappearance and subsequent death of their son, which otherwise stymied their claim. It was their pursuit of that claim which challenged the court to consider whether the facts were sufficient at law to give rise to an independent, tortious duty of care owed by the defendant cattle station owners to the parents to exercise reasonable care and skill to avoid causing them psychological injuries. The law's history did not bode well for the suffering parents. The plaintiff's arguments in terms of the proceedings in the Supreme Court of Western Australia. As the employer knew of James' youth and inexperience as a jackaroo and the concerns of his parents for his well-being, it was reasonably foreseeable by the employer that they would suffer psychiatric injury if he was harmed as a consequence of the employer's negligence. However, his owner held that the employer did not owe a duty of care to them in respect of nervous shock because the psychiatric injury they suffered was not the result of a sudden sensory perception arising from them being directly involved in the harm-causing events. This was because Mr. and Mrs. Annetts were separated in time as well as in space from the distressing events, and because they learned of his death and disappearance by telephone.
So I'm going to be discussing the relationship giving rise to a duty of care. As this judgment indicate, the case was argued and decided in the Western Australian court on the basis that the employer's liability was governed by the special rules that usually determine whether a person is liable for the negligent infliction of pure nervous shock. But those rules do not apply to and do not govern this case. They are concerned with situations where the parties have no pre-existing relationship and where, before the suffering of nervous shock, there was no duty on the defendant to take care to avoid injury to the plaintiff. On the current state of authority, it is enough that although there is no pre-existing duty or relationship, the defendant ought reasonably to have foreseen that his or her conduct might cause nervous shock to the plaintiff. In the present case, the assurance of the employer gave rise to a duty on its part to supervise and take care of James so as to avoid inflicting harm on Mr. and Mrs. Annetts. The consideration for their concern to his going to Flora Valley and working for the employee was the assurance that the employer would supervise and take a good care of him. They could have sued in contract, but they elected to sue in negligence under the general law. The result is the same. The assurance of the employer gave rise to a duty, the breach of which entitled Mr. and Mrs. Annetts to sue for any damage suffered that was reasonably foreseeable in a general way. It might be expenditures incurred in paying for medical treatment for their son or in searching for him if he became lost, or it might be injury, personal or psychiatric, suffered by them.
The facts pleaded show that, under the general law, the employer owed a duty to take reasonable care to avoid harm to Mr. and Mrs. Annetts. They also show that the employer breached that duty and that the harm suffered was not too remote from the employee's breach. Even if, for policy reasons, the common law continues to maintain distinction between actions for the negligent infliction of physical harm and action for the negligent infliction of nervous shock, psychiatric illness is not damage different in kind from physical injuries. Arguably, the employer also owed a fiduciary duty to Mr. and Mrs. Annetts, as well as to their son. But that duty, like contractual duty, was not pleaded. Nevertheless, the facts pleaded were sufficient at law to give rise to an independent, tortious duty of care owed by the respondent to the applicants to exercise reasonable care and skill to avoid causing them psychiatric injuries.
Okay, so this is the end of our presentation. Thank you for listening. Bye!
Bye.